Thank you very much for joining us for another video. What we're trying to do is, this is the second video of a multi-part series. I thought originally it'd be 12 different parts, but now I'm thinking it's going to be more like 20 because Rob Siegel here loves being in videos with me. He loves when I interrupt his work and I drag him in here to shoot videos for sellers. So what we're going to be talking about in this video is how we handle Amazon sellers who receive intellectual property right complaints, or otherwise called rights owner complaints. So Rob, a seller gets a intellectual property right issue, a complaint, and either account goes down or they lose the ability to sell that listing. What's the very first thing you do?
Well, CJ, the first thing we have to do is establish whether the complaint is valid. So we'll look at the listing identified that belongs to our client and the theory of infringement identified in the letter or notification that our client received, and try to determine if the complainant has a valid reason for reporting our client. Most of the time they don't.
Now, it's pretty easy for us to do the evaluation. We're all lawyers, we're all experienced in intellectual property law, and intellectual property law is not rocket science. It's basically 4 categories. There's trademark, copyright, patent, and trade dress. So if we look at your product and we know there's no violation because you're selling a genuine product, it makes that correspondence to whoever made the complaint, the complainant, pretty easy to do. And that's what we do. We write to them and explain why you are not violating anybody's intellectual property rights. Okay, now it's different if you are, but let's take the assumption that our seller has simply bought and sold a product either from a distributor or from a warehouse or retail arbitrage, and they just bought and sold it, okay? So we draft a letter and we explain why they're not violating each of the basic areas, right?
Correct.
So quickly run through the basic areas of intellectual property law: trademark, copyright, patent, and trade dress, and why a seller who simply bought it at the discount rack in the Walmart and is reselling on Amazon, why they're not violating anybody's rights.
Okay. So there's something called the First Sale Doctrine that applies broadly throughout almost all areas of intellectual property. It's called something else in patents, but the idea is basically the same. Essentially, as long as someone is buying and selling a product that matches the condition it's received in when purchased from the manufacturer, then they're excused from any potential liability for intellectual property infringement.
So here's the basics, okay? As long as the third-party seller, meaning you guys, deliver a product to the consumer that's not, here's the legalese, that's not materially different than what the brand would deliver, you're not violating anybody's rights at all. It's their product, so of course it's their packaging. It's their product, so of course it has their logo on it. It's their product, so therefore it has their copyright. It's their product, therefore the trade dress claim is nothing, because you're buying and selling their product. Now, is there also, if a brand refuses to withdraw a baseless, a bullshit complaint, okay, does that brand have any potential liability?
They do. The most important thing to consider is that on Amazon and most e-commerce platforms, there's a penalty of perjury provision that all complainants must click and agree to before submitting a complaint. Basically, all complaints on Amazon are submitted under penalty of perjury, that the person submitting the complaint has authority to submit the complaint, and that they have a good faith basis that the complaint is valid.
Now, clicking the penalty of perjury really may or may not subject them to much, okay? There's no one swearing them in, it's not a court of law, it's not a government document, but it does create some liability. And if they submit a baseless complaint and they knock you out of business, they could also be liable for your damages. If you're a small seller doing $5,000 or $10,000 a month, they're responsible for that because they knocked you out. And there's what's called the intentional interference with contract, and also the whole fraudulent claim of just submitting a baseless complaint. And if you're a seller doing $100,000 to $300,000 a month or $1 million a month, they're also just as responsible if they knocked you out of business with a baseless complaint. And we have seen this over and over and over again from small brands as well as large brands. But let's say it's not going there. Let's take the next step. We draft a letter, we send it to the brand manager or to the brand saying, your complaint is baseless and this is why. What else do we do in terms of negotiating the withdrawal of that complaint?
Well, one of the benefits of hiring our firm is that our attorneys are all willing to pick up the phone and call the rights owner. And if their information is not provided, we've done this so many times before that we've already established relationship and gathered that information. Or we have the ability to to visit the USPTO databases and backtrack who they are based on which attorney filed the trademark. So it's not necessarily something that anybody can do, but it's something that we can do, and it's something we do all the time.
I could also tell you sellers, and I think it sucks, that often you will write to the complainants and the sellers will write to the complainants and no one's going to respond. It's very rare that our law firm writes to a complainant and we don't get a response. It has happened in the past, I'm sure it will happen again, but generally when they see our letterhead or any lawyer's letterhead, they're going to respond because they know you have some backup, they know you're taking it seriously. And Rob also mentioned that we have dealt with dozens, if not hundreds, it's got to be hundreds by now, of different brands, their lawyers, their brand managers. And with a lot of these people, we have really great working relationships. We've dealt with Major League Baseball, NFL, Disney, Marvel, Epiance, Johnny B, and that's just off the top of my head. So often we'll kind of know how it's going to play out because we know the personalities of the people we're dealing with. And some of them are a lot easier to deal with than others, of course. But those kind of relationships certainly help in negotiating the withdrawal of the complaints asserted against your account. So thank you very much for joining us. All the issues we discussed in this one video are also going to have their own videos where we're going to talk about each one, and you're going to really learn all about trade dress, and we're going to teach you all about trademark. We're going to teach you how to apply for your own trademark and copyright. So Rob, thank you very much for coming on.
Thank you.
Some of my team members love when I say, come on in here and let's shoot another video. Others don't really love it. Rob sometimes is in the middle. So thanks for coming in. I don't allow any prep session. We just shoot this because we are here, if nothing else, to give you information to help yourself. So please share and like the video. Or more important, like the entire Facebook page. That helps us tremendously. It helps us get the word out, helps us share information to sellers all over the world. So thank you very much.
Thank you.